soon to be this afternoon's docket. Case number 111361, State of Kansas v. Robin Boggess.
Good morning. May it please the Court, Carol Longenecker-Schmidt of the Appellate Defender Office representing Ms. Boggess. Mr. Chief Justice, if I may, I would like 3 minutes for rebuttal.
3 minutes is granted.
To offer a very brief procedural overview, this is an appeal of Ms. Boggess's drug-related convictions in the district court. She ultimately was convicted by a bench trial, and before that conviction, she filed a motion to suppress evidence seized during a search of a car in which she was a passenger. The district court denied that motion. She was convicted, appealed. The Court of Appeals affirmed the district court's denial of the motion, and Ms. Boggess filed a petition for review, and that brings us to this point here today. The main question in this case is whether the driver of the car in which Ms. Boggess was riding had apparent authority to consent to the search of her black bag. To answer this question, it all depends on the starting point, the point at which this court decides to start. The standard to determine whether a person has apparent authority to consent to the search of another person's belongings is whether an officer of reasonable caution would believe that the third party had common authority over the place or belonging being searched. The Court of Appeals chose a different starting point. The Court of Appeals created a standard whereby it assumes that a driver has apparent authority over a passenger's belongings, unless there's evidence that shows otherwise. My reading of the Court of Appeals holding and its interpretation of the federal case law is that it's coming in with an assumption that the driver always has apparent authority to consent to the search of belongings in the car. But I don't think that that's the standard.
I thought there was a notion here that the officer wouldn't necessarily know that the black bag belonged to somebody else because your client's purse was accounted for prior to this. So this is an additional thing that's in the car. And so why would the officer think that belonged to somebody else?
I think there's a couple of reasons. I think her purse, my memory is that Ms. Boggess didn't say, "Stop, that's my purse," until after the black zipper bag was searched. I think that was the very first thing that was searched. Officer Jones testified at the suppression hearing something like, I had a pretty good idea that that was probably Ms. Boggess's purse. That was his impression.
There was an inference of her about which purse was hers, though, right? Because she had reached into it for her ID. Wasn't there something about that the police officers would have known it was her purse because that's where she went to get her ID?
I do not recall that, but that
Okay.
sounds consistent.
Okay. Even if they searched it after the bag, which I think you're right is what the record reflects.
Yes. So the question is, was there any evidence that would show that the black zipper bag belonged to the driver, or that the driver had access and mutual use of that bag? So the Court of Appeals essentially said, well, there's no evidence to show that, to tie it to Ms. Boggess. That's one factor, but there's no evidence to really tie it to the driver either.
Isn't the fact that it's in the driver's car evidence that it's tied to the driver?
Well, that's one interpretation. Another interpretation is that it is in the driver's car, but there's two people in the car. There's a passenger in the car. It's closest to the passenger. And so if you see a closed container in a car in which there's two people, particularly when it's closer to one person, you don't know. It's ambiguous. And when it's ambiguous, an officer has a duty to inquire further and to ask, whose bag is this? Another factor in this case that shows the ambiguity of who owned this bag was Ms. Boggess's objection to the consent or to the search of her purse. My reading of the record is it's actually unclear whether Ms. Boggess knew that the driver consented to the search of the car. One officer testified something to the effect of, well, I'm pretty sure she heard it. She would have had to have known that the driver consented. But there was also testimony that it's possible that the consent was given when the driver was standing outside of the car and Ms. Bogus was still seated in the passenger seat and possibly talking to Officer Jones.
So how does that figure in the calculus?
So I think that says that, or shows that Ms. Bogus may not have been aware that the officers were going to search the car, or more importantly, maybe that the officers were going to search the car and her possessions. There is one scenario under which we could assume maybe she knew they were going to search the car, but not necessarily go into her personal possessions, which is supported by the fact that when she's standing at the back of the vehicle and she sees officers going into her purse, she says, "Wait, stop." I can't think of a logical conclusion why she would object to the search of her purse, but not object to the search of her black zipper bag if she saw that, if she knew that that was happening.
But she also didn't take it with her.
That is
She
true.
exited without, and so when we're talking about implications, as my colleague says, you have the owner and the controller, driver of the vehicle, and things in that vehicle. So there's a matter of control over your whole vehicle. And you have the fact that she exited without taking her possessions with her. And so, I mean, there's two implications. If that was hers, why wouldn't she take it with her?
Well, one interpretation or one answer to that question is because, for the facts I just sent it, she may have not known the car was going to be searched. An officer says, "Get out of the car." You get out of the car, you may not. It can be a stressful situation. You may not think, "I'm going to grab all my personal belongings." So if she didn't know the car was going to be searched, that's less of a motive to take it with you. And even if she did know the car was going to be searched and she left it in there, I think that still brings you back to the starting point of it's still unclear whose it is, because you're still presented, the officer enters this car with lots of possessions in it, and that possession is closest to her purse and her seat. It's true that the driver could have reached over and touched it, maybe could have accessed it if she wanted to, but mere access doesn't show that a driver has authority over that item. The standard for determining whether a third party has apparent authority is whether the officer believed the person had common authority. And authority is more than just mere access. It's also use and authority to consent to the search of something. And so, yes, the bag was nondescript. It didn't have, RB, the initials on it. It didn't have the driver's initials on it. It was nondescript, but that's a fact that makes it ambiguous. We don't know.
In your view, was it consistent with the argument you're making, and the Court of Appeals relied on the Pedraza case, which is another Court of Appeals case where there was a apparent consent to search the duffel bag in the trunk, I think.
Yes, I already...
I'm sorry, I was just going to... Do you think that case, that holding's wrong also?
Yes, I do.
Okay.
Yes, I do. I think that case starts from this other point of assuming...
You're not trying to distinguish this case from that earlier case. You're just saying that whole line of cases is wrong.
I just think that's wrong.
Okay.
I think that was also an ambiguous situation there, but my argument is that Pedraza is incorrect. And if we look at the officer's testimony at the suppression hearing, I think this is the most significant supporting evidence that we have that the driver did not have apparent authority, because he testified, "We had no idea what property belonged to who. I mean, like I said, it was pretty cluttered. We didn't know." And then he says, "I didn't know whose was whose, other than the purse. I didn't know whose stuff was what." So the officer is saying, I didn't know whose bag this was. There was no information to show that the driver had authority over that bag. And in that situation, our argument is that an officer has an obligation to simply ask, whose bag is this?
There was it appears it doesn't factor into this at all, but there was a child in the back seat,
Yes.
and then there's no mention of that, and I'm just wondering how much that might factor in, those of us that have kids, the cluttered nature of the car, but also as to who, maybe it was one of a child's possession, but that never entered into any of the equation. It just seems that got lost.
I agree. That I noticed that. I don't recall any testimony about the child. My experience is also that having a small child creates too significant clutter in a car, and they have lots of things that.
Right.
But that is not in the record.
It's
my experience.
nowhere, and I'm just more.
Yes.
As much of a.
I agree that I saw that
curiosity.
fact, but I think it was
Okay.
downplayed or lost.
Any further presentation?
No, Your Honor. I would simply request that this court reverse the denial of Ms. Boggess's motion to suppress.
Do we have any more questions? Thank you, Counsel.
May it please the court. Again, I'm Joseph Penny, representing the state of Kansas on this case. This is an apparent authority case, and the Caratesi case, citing a number of federal cases, does say that apparent authority is when the facts available to an officer would warrant a person of reasonable caution to believe that the consenting party had authority over the premises to be searched. And that case also does say that where there's ambiguous facts relating to authority, the officer's under a duty to inquire further. So I think kind of a foundational issue here is what ambiguous facts means in that context. And I guess I'd submit first with some ideas of what it can't mean. It can't mean that in 2020 hindsight, there's some other articulable explanation of what the facts and circumstance showed, because that's almost always going to be the case.
Well, this is a bag and not a purse.
True.
But if we're looking at reality, if there's a purse on the passenger floor in front of a passenger, the nature of that particular item would give most of us a reasonable assumption that it belongs to the passenger, because you usually don't have joint control over a purse, and it's usually in close proximity to the person that possesses it and owns it. So how does that factor in when you had the purse laying on the floor in front of the passenger and the bag next to the purse?
Well, I think that, it's really kind of a separate question, and I would say that, if the officers had some question about if they could search the purse, they probably did have a duty to inquire further about that purse. But that's in part because of the nature of the purse, and, this court and Kansas courts have recognized that there are some items that, do kind of by their nature, call out to being private items, particularly associated with an individual. Additionally, a purse is an item that one might bring into a vehicle if they were going to be a passenger in the vehicle. It's an item that one might travel with during the day. Other items aren't necessarily like that. There's the single boot in this case. A person wouldn't necessarily bring their single boot with them when they're traveling as a passenger in a vehicle. So, I think the black bag here is just kind of different as well. It doesn't have its own indicators, of privacy in and of itself. It's something that you might expect to be inside someone's purse. It's out, it's in the same footwell as the purse. I'm not, totally clear how close it is to the purse. It's laying on top of that single boot. And again, you've got a situation here where there's quite a lot of clutter, so this case might be different than another case where, in the passenger footwell, there's a purse that's probably the passenger's, and then there's a little bag leaning up against it, and, that's all the rest of what's in the car.
Does the record tell us how big the bag is?
Yes, I believe the officers testified that the bag was something along the lines of 2 to 3 inches long, or 2 to 3 inches wide, and maybe 4 to 5 inches long.
Okay.
So that's one of the officers testified to a size approximately in that
Almost like
range.
a glasses case. Or...
Yeah, about like a glasses case. And the officer also indicated that that's a case that he'd, similar to cases he'd found drugs in before. So, I think that, again, it can't just be that there's any explanation, because in prosecuting drug cases, I've had the drug defendant try to use the defense that, well, you were found with drugs in your pants. These weren't my pants. I put these pants on, but these weren't my pants, or this wasn't my jacket. And in a certain sense, that's possible. But I don't think that an officer seeing that person walk down the street, would have any kind of ambiguous facts that if, I ask you for consent to search those pants that you're wearing, you're the person who can give those to me. Now, I think that, the appellate might distinguish this case and say, that's kind of an outlandish claim. This is more of a reasonable claim here, and I think that's even in, the petition for review that perhaps, what the court said, that it's reasonable to believe that the driver would have put this bag, over to kind of keep it out of the footwell, and it's still within her arm's reach is reasonable. But the appellant says, well, there's another reasonable possibility, and it's the passenger's bag because it's in the passenger's footwell and it's, located over there. But I don't even think that there being another reasonable possibility should be fatal to the state's case here.
Why not? Why doesn't that make it ambiguous?
Well,
I'm
Your Honor,
having trouble, just to be honest, reconciling the two statements.
sure. Justice, I'd ask you to look at, and I'd ask the court to look at what the standard of proof is in a criminal case, and that's beyond a reasonable doubt. So, when we contrast that with the standard of proof or standards of proof in a civil case of, preponderance of the evidence or clear and convincing, I think the legal system kind of accepts that there are going to be things that, we're clearly convinced that this is the circumstance, but maybe there are some other possibilities that are reasonable, and that's kind of when we're in between, clear and convincing evidence and beyond reasonable doubt. So I think just the fact that there's some other possibilities that one could term as reasonable here, all that says is this officer hasn't met the highest standard that we have in the criminal law.
Well, but flip it. What is the test that if it's reasonable to conclude that something that's by the feet of the passenger might belong to the passenger, that makes it ambiguous and the officer has an obligation?
I don't believe so, Your Honor. I think, again, all that says is that we don't approach the standard of beyond a reasonable doubt. I think that perhaps if an officer had probable cause to believe something,
Why say, kind of going back to my statement about I'm having trouble understanding how these fit together. Why make a reasonable officer standard and then say, but if it's ambiguous? If we're just going to say, yes, it's reasonable for the officer to conclude it, why isn't that period, end of story, we're done? But it's not. There's also this injection of, but if it's ambiguous. And so how do we, I think you are asking the same question. How do we determine what is ambiguous? And I'm suggesting that maybe a reasonableness standard applies there as well. Do you have another explanation of how to merge those two? Or
sure. I think my answer to that would be that if the standard is there's not any other reasonable possibility, that really does set the standard quite high. We allow officers to arrest individuals based on probable cause, and an arrest is a pretty significant thing. That's a deprivation of liberty. And, even an arrest, at the level of probable cause, there could certainly be other reasonable explanations to what had happened. They might be less probable than not, but, there could be other reasonable explanations. So, I think if we have a standard, even at the level of probable cause, I think it would be met at this case. I think it could reasonably be set at a level of reasonable suspicion to believe this belongs to someone.
Someone else, the passenger. I'm having, yes, it might be a reasonable belief it belonged to the driver, but is it also reasonable suspicion that it belonged to the passenger? So how do we eliminate that?
I would say that probably a probable cause standard would be pretty valid, because then we're at least saying that, well, we think there's 50%, plus one, that this belongs to a person. And, in a certain standpoint, if something's 51% likely, something else is 49% likely, you could say that's ambiguous. But I don't think that can be what ambiguous means here, because then we're really holding officers to a much higher standard in determining...
Why shouldn't we? Why shouldn't we hold the officer to the standard of turning around and asking the driver and the passenger, I've got this bag, who does this belong to?
Well, I think we have to limit the standard we hold those officers to. I mean, for the same reason that we do it with arrests, and we don't say, officer, you have to believe beyond a reasonable doubt this person's guilty. We say you have to have probable cause. It's, because these individuals aren't perfect, so we have to have a way to make the system work. Now, I know that there's probably an idea that, well, maybe we could have solved this quite easily if we had just asked, who does this belong to? But I don't know that it's necessarily, realistic to believe that a statement of ownership from someone, particularly when the item is a bag that contains illegal drugs, is necessarily going to be forthcoming or necessarily going to be more accurate than other information that an officer can obtain on the scene.
What we're talking about is an exception to Ms. Bogus's Fourth Amendment right against unreasonable searches. And you're using the consent exception, but not her consent. And so if you look at it from that standpoint, I would re-ask my colleague's question, why don't we hold the officers to a higher standard and make them ascertain whether they really do have consent to violate the Fourth Amendment rights of the passenger?
Well, again, I think it's just something that's, unrealistic to expect perfect information. And we have this apparent authority doctrine, and it's been applied by a number of courts. If the standard was, officer, you have to be absolutely sure, beyond a reasonable doubt sure, then I don't think there's really any point of having an apparent authority doctrine, because they're going to be held to a standard that, they're going to darn well need to be right, or it's going to be an incredibly unusual situation where they're not.
So what we would be doing is requiring the officers to obtain a voluntary, intelligent, and knowing waiver of a constitutional right.
I think that the officers here did their best to do that and did a reasonable job to do that under the circumstances.
Where did the ambiguity question sort of arise in the course of the development of this doctrine of apparent authority? Do you know?
Well, I don't know if I can say. I know the Caratesi case, which...
Is that it?
Well, I think that's the
question.
first time it's been applied in this state, as near as I could find it. And I actually did try to do a Westlaw search, to try to find, again, a definition for what do we mean by ambiguous facts. So tried to do a Westlaw search for ambiguous facts in the same paragraph as apparent authority. And in Kansas, I only found 2 cases, the Caratesi case.
The Caratesi case doesn't cite anything, does it, for that proposition?
It doesn't cite any other Kansas cases. It cites some 10th Circuit cases, I think. And
for the specific proposition about if there's an ambiguity?
For that phrase, that where there are ambiguous facts relating to authority, there's a duty to investigate further. So, and then the others, Kansas case that cites that is the Court of Appeals case in this opinion, or this decision. I did look at 10th Circuit because I noted that Caratesi cited it, and there's a few 10th Circuit cases that use that ambiguous facts, language around apparent authority. None of them really seem to have a clear definition either, and we're talking about 9 or 10 cases there, so not a great many. There were a few that noted a citation from Professor Lefebvre's Search and Seizure Treatise, and that quotation was sometimes, quote, sometimes the facts known by the police call out for further inquiry, and when this is the case, it's not reasonable for the police to proceed on the theory that ignorance is bliss. And that's probably a true statement, or it is a true statement, but my argument is the facts here did not cry out for further inquiry. First off, we've got a driver of an automobile, and I would advocate, a rule or, just a consideration that really should be a substantial factor in considering, well, does this person have authority to consent to search for the contents and subcontents of this automobile? You know, the fact that they're the driver, that they're exercising dominion over the automobile, that should be significant, and it's a significant difference from Karatesi. You know, I think to have a similar situation in Karatesi, that bus that was kind of out behind the property would have had to have been inside the house, and then the girlfriend would have had to have been paying the mortgage or something like that. So, you know, I think it really is a significant amount of dominion. It's different. You know, a passenger somewhat assumes the risk as a result of that when they get into a vehicle with someone else who's driving.
I just have a question. Is there any interplay between apparent authority and constructive possession? In other words, if the defendant here didn't object that it was her, could the driver, is it Motley or Motley, however you pronounce her name, been prosecuted like under a kind of constructive possession theory?
Well, I mean, we certainly didn't seek to do that, and you know, I think either.
I'm just curious
Sure.
of the interplay.
Yeah.
Is there any?
I could see that there could be in certain circumstances. I'm not sure that there would be here, because there's just, to me, not enough facts to say that even from a constructive standpoint that, you know, once law enforcement interviews Ms. Bogus at the police station, she says, yes, the small black bag's mine, the items in the purse are mine, that there's really enough there to say, well, this opaque bag.
Absent that,
Sure.
could you pursue a prosecution against the driver for possession of that based on conduct?
Sure. I mean, I think that's a possibility. It certainly would have warranted further investigation, or warranted perhaps an interview with the driver, and, you know, to see, you know, what she would say to explain kind of what the items were in her car, how they got there, you know, what the result of all this clutter was. So, you know, I think I could see an interplay there. I do note that this probably, a lot of these apparent authority cases talk about something where, you know, someone at least had kind of partial authority, you know, with someone else. This case doesn't really seem like that to me, because I don't know that it would be reasonable to think that two people would have, you know, exclusive rights to a small eyeglass carrier. I think it would be more reasonable for the officers to think that one person has right to, you know, consent for us to search this, and that one person is the driver of the vehicle that it's in.
Why? Flip it. If you had drugs or a gun or something under the feet of the passenger, wouldn't you possibly have a constructive possession case against that passenger?
I think
So
you
why-
would.
So why aren't other items that are within the reach of the passenger, at least ambiguously attributable to the possession of the passenger?
Well, you know, I think that, again, it's kind of a question of what ambiguous means, and if it's quite high standard, you know, at some point you're going to get there with those items. But, you know, again, I think that if you talk about a gun or some drugs that's under the passenger seat, you know, you're in a more difficult situation pursuing prosecution, and you might be in a more difficult situation, you know, with either the driver or the passenger, because you could argue, well, that's kind of in the area where a passenger could have reached down and put it there. But on the other hand, that's also in kind of an area where, you know, it could just be under the seat with all this other clutter, and maybe the passenger has no idea. You know, in this case, we've kind of got this bag that's sort of, at least to some degree, on top of things, that, you know, there was a finding that it was within the wingspan of the driver. You know, I think both the Court of Appeals and the District Court indicated that, you know, given the need to keep the pedals sort of clear and free for operation, that's something that's anticipatable, property of the driver ending up over on that area. And then again, you've got the fact that, you know, this is just a very cluttered car, and, you know, even the officer said, you know, we don't really know, know who these things belong to. I mean, again, we've got the subjective versus objective thing that, you know, courts talked about in several cases here, but even he kind of pointed at some facts that would indicate that a lot of those items had been in the car for a long time, and that they're kind of cluttered, layer over each other, people are stepping on them. And I think, again, you know, if you're looking at an objective standard, items that have been in the car for apparently a long time is indication that belongs to the driver. So I do think that it's fact specific, and, you know, all the facts in this case probably matter, but I think the strongest fact and the most significant one is the fact that this person's the driver of the vehicle where this item's located. And I do note I'm out of time. If there's no other questions, I just conclude and ask this court to affirm the holding of both the Court of Appeals and the District Court here.
Do we have any more questions? Thank you, counsel.
Thank you.
Unless your honors direct me otherwise, I'm prepared to waive rebuttal.
Any objection to counsel waiving her rebuttal? I see none. Thank you, counsel. We thank both of you for your arguments this morning and this afternoon. Court will take this matter under advisement. This time